Hello, everyone, and welcome to my introduction to this week's podcast. Another really extraordinary conversation with my friend Beau Breslin of Skidmore College in upstate New York. He's the author of several books on the U.S. Constitution. He's been a frequent guest on this program. He's one of my go-to individuals, and I love our conversations. And today we talked about habeas corpus. Habeas corpus, in a nutshell, means produce the body. There has to be due process. You can't be detained indefinitely. There has to be some sort of a legal proceeding in which your body is actually brought to court, so we know you're still alive, that you haven't been banished to El Salvador or somewhere, and that you're entitled to certain protections of due process, that you just can't be arbitrarily arrested and detained. And as you all know, that principle is under enormous erosion at the moment. And Kristi Noem, the governor of South Dakota, not North Dakota, testified before Congress, was asked what habeas corpus is, and got it so wrong that the whole world should blush. The whole world that cares about human rights should blush and demand that we do better. But that was the starting point, and we had a really lively conversation about the history of habeas corpus, how agonizing its history has been, how we ourselves, say Japanese internment in World War II, or Abraham Lincoln trying to hold the Union together, or the Alien and Sedition and Alien Enemies Act of 1798, that we, the United States, even though habeas corpus is guaranteed inside the Constitution, not in the Bill of Rights, we have failed from time to time in times of perceived or real national emergency, and we need to acknowledge that. But it seems to me, and Beau and I agree, that habeas corpus, although not sexy, is the most important of all rights, and it has been established beginning really in the Roman Republic, but beginning to find its formulation in the Magna Carta and in British common law, and then the 1679 Habeas Corpus Act in England, and then incorporated here in the United States. It's absolutely essential, and yet most people don't know what it is. Most people regard it as just some legal nicety, or who knows what, some procedural thing. It's not. It's fundamental, and we're violating it. And the argument that the Trump administration is making, and I defended it, at least in principle, in other words, it's not indefensible. The argument that they're making is that the tens of millions of people that they perceive to have crossed the border illegally over the last 20 or 30 years amount to an invasion force. An invasion is one of the reasons stated in the Constitution for which a president can temporarily suspend habeas corpus. I don't happen to agree with that. I don't think that this is an invasion at all, but I think the case can be made legally and might prevail legally that tens of millions of people illegally crossing the border of the United States is an invasion in some sense of that term. That will be decided by the courts. I don't feel very confident about the decision, but I will say this. You probably don't think about habeas corpus. I urge you to. I urge you to listen to this program with great care. I wrote an essay towards the end. I'm reviving the old tradition of the Jefferson Watch. People have asked me to do that, and I think it's important. We're in for a wild ride here. We're in for a wild, wild ride in which the norms and the protections that we all thought were settled are being challenged quietly or overtly every single day. And it's not just the Trump administration. This erosion's been going on for a long time, and he's not the sole abuser of the doctrine of habeas corpus, but he's the current one. And this is a very grave constitutional and human rights situation. Anyway, join the Friends group, please. Join our book club. We're about to start in on The Short Life of the Shadow Catcher, which is the story of Edward S. Curtis, the great glass plate photographer who took 40,000 images of Native Americans between 1900 and 1935 and produced the most important archive, ethnographic and otherwise, of indigenous people in our history. So tell your friends, circulate this program if you think that it's valuable. Urge other people to become members, to pick up our weekly newsletter, which you get free just by going to ltamerica.org. The Lewis and Clark journey is over now. I will have one or two more essays about it, but then I promise I will move on to other things, but it has been such a delightful summer. And I'm happy to say that today, as I record this, I'm in my own home, in my own office with a better microphone system, and I apologize for some technical glitches that have occurred in the last few weeks. It's been quite a scramble trying to do all of this from within an Airstream using sometimes intermittent Starlink technologies, and it turns out even an errant Tascam professional recorder. So thanks for your patience. I promise it'll get better, that we have already fixed the issues. So let's go to the show. Thank you. I'm so glad to be home, and yet I already miss my life on the road, but I'm planning for 2026. We'll see you down the road. Hello, everyone, and welcome to this special edition of Listening to America. I'm Clay Jenkinson, and across the country from me at Skidmore College in upstate New York is my friend Beau Breslin, a frequent contributor to this program, prolific in his books. He has that crazy book about rewriting the Constitution once per generation. I agree with the principle. I'm not sure how well we would actually do with it. Today, we're going to talk about habeas corpus, that sexiest of all human rights. Welcome, Beau.
Clay, it's great to be back. Always great to be with you.
If we can make this fun, then we obviously know what we're doing. It doesn't need to be fun. It just needs to be clarifying and interesting. I mean, our purpose is to help people, our listeners, understand what's going on around us in the context of history. And I find that most Americans don't really understand what habeas corpus is, and therefore they aren't alarmed by its erosion at the current time. I just want to play for you a clip. Kristi Noem, the Director of Homeland Security, before the United States Senate on May 21st, 2025. New Hampshire Senator Maggie Hassan asked her to define habeas corpus. So here goes.
Well, habeas corpus is a constitutional right that the president has to be able to remove people from this country and suspend their right to.
Let me stop you, ma'am. Habeas corpus, excuse me, that's incorrect.
President
Habeas
Lincoln
corpus,
used it.
Excuse me.
Mm-hmm.
Habeas corpus is the legal principle that requires that the government provide a public reason for detaining and imprisoning people. If not for that protection, the government could simply arrest people, including American citizens, and hold them indefinitely for no reason. Habeas corpus is the foundational right that separates free societies like America from police states like North Korea. As a senator from the live free or die state, this matters a lot to me and my constituents and to all Americans. So Secretary Noem, do you support the core protection that habeas corpus provides, that the government must provide a public reason in order to detain and imprison someone?
Yeah, I support habeas corpus. I also recognize that the president of the United States has the authority under the Constitution to decide if it should be suspended or not.
So, Beau, Kristi Noem could not have been more wrong. You'll explain that in a moment. She got a chance to correct herself. The senator from New Hampshire said, "Oh, wait a minute. I'm going to give you a chance to say first that this is a protection of people's legal rights against government. If you want to say that under certain conditions, including, for example, the Civil War, the president has the authority to suspend habeas corpus for a short time, we can listen to that. You can't start off defining habeas corpus by granting government the right to make someone disappear without due process." When I heard that, Beau, I was flabbergasted, frankly, because I would think that anyone who's going to be the Director of Homeland Security, which is all about habeas corpus, that's the center of what's going on to deport undesirable people from this country, I would have thought that that person would be spot on with that legal doctrine, which is fundamental to all free societies. When you heard that, what did you think?
Yeah, I was shocked. I was shocked by the ignorance, but I was also shocked by the Director Noem's inability to understand how important, as you say, Clay, how important habeas corpus is. It is considered historically the great writ, right? It is, in some respects, the most important individual right we all have. The ability of government to require that a person under arrest be brought before a judge, especially when that person is detained, and being told what they're being detained about. That is the most important right in any free society. Tyrannies, one of the first things they do is get rid of that particular right, get rid of habeas corpus. And so for her to not be able to understand that and go immediately to Trump's ability to suspend it strikes me as a real colossal mistake.
I sense maybe she was coached on what kind of an answer to give to that question. Let's just go through a sort of a test case here. So let's say that I am a Mexican who I work in Southern California. I've been here for 30 years. I hold a job. I pay Social Security. I pay sales tax. I obey the laws. I have a family, but I'm not documented. I am an illegal immigrant. ICE can snatch me off the street and put me in jail. And Kristi Noem has asked for a fleet of airplanes, of jets, to fly people out of this country to other places, sometimes places that have nothing to do with their nation of origin. If there is habeas corpus and I pick you off the street, what does habeas corpus require of me now?
So habeas corpus requires that you appear before some sort of judge. It may be, Clay, it may be an administrative judge, it may be an immigration judge. These are not Article 3 judges, but appear before a judge before you're deported and essentially told why you are being thrown in jail. And what's interesting about this whole thing is that our freedoms, people don't understand this, or maybe Kristi Noem doesn't understand this. Our freedoms, those that are embedded in the Bill of Rights, those are embedded in the Article 1, Section 9, whatever, are constitutionally granted based on territory, not based on citizenship. So if you're in the United States, regardless of whether you're documented or not, you get a certain level of constitutional freedom, a constitutional protection. So if you get thrown before a particular judge, it may not be the same as citizens, but you have the constitutional right to hear why you've been thrown in jail by virtue of being on this territory, on this land. Citizenship doesn't give you the right. Your ability to, your capacity to be on the territory of the United States grants you the right. And that's what makes America different than so many other nations in the world.
And habeas corpus is enshrined also in the United Nations Universal Declaration of Rights. It's now regarded in all civilized countries as a foundation right for which every other right is indebted. I have to charge you. So I say, under the doctrine of habeas corpus, if I snatch you off the street, I have to charge you formally with a crime. Your crime is that you are here illegally. You cannot produce papers to show that you're an American citizen. That means you crossed into this country illegally. You have violated federal law. I, therefore, as a member of ICE, have a right to arrest you. And now we're going to do what? Now we're going to have a hearing, right?
Correct. And it's truncated. It's not the same as a hearing you would get if you were a citizen and you violated some federal law with regard to the right to free speech or so on. But there is a guarantee that you would appear before immigration judge to hear the charges. You're not being, for example, Clay, you're not just being shipped from whatever employment I have to the plane and deported to El Salvador or Uganda or wherever they're sending them these days.
All right. So there has to be a formal explanation of why you have been arrested and why you're being held. There must be an actual, visible, transparent, doesn't have to be public, but it has to be one that can be challenged hearing in which you can make the case for yourself or the charges can be leveled against you. Then once you are convicted, let's say you are, normally in our system, there are possibilities of appeal. So when an ICE officer appears wearing a mask and refuses to show his badge, is that a violation of habeas corpus?
Well, I guess technically not. I mean, because, the existence of a uniform, mask or not, doesn't necessarily change the fact that you still need to appear before the judge and be told why you're being held, why you're being constrained. So, that's sort of part of the political dynamic of habeas corpus. But legally, really, all the government, and I'm not saying this is a minimal thing, all the government is obligated to do for you is tell you why you're being detained.
But wait a minute. How do I know? Say I come in and snatch you out of your classroom.
Yeah.
How do you know if I'm masked and don't show credentials, don't show a badge? How do you know I'm an officer of the federal government? What if I'm just some student who got a D- in your politics class? I mean, literally, how do you know if that person doesn't show their credentials that this person has the authority to arrest you?
I would think that you wouldn't, and I would think that that would be quite horrific for me being snatched. At the end of the day, this is where it gets to be tricky, right? This is where it gets the definition of habeas can be broadly expanded or not. And I'll take another little historical tour. One of the things that's interesting, Clay, about this particular moment is that the heyday, the high point of habeas corpus protections against those who are detained was in the Warren Court era. And by that, I mean those who were detained by, those who were accused of state crimes could go, often the Warren Court would allow them to go to federal court to claim habeas corpus and seek some redress from state court detention, right? Since that time, since the Warren Court era, so let's say roughly 1970, well, since that time, we've had a slow erosion of habeas. First with the Anti-Terrorism and Effective Death Penalty Act in 1996. This is part of the Bill Clinton being tough on crime mentality. We've had a erosion there. Those who were detained were limited in the number of petitions they could submit. And two, they only had a 1-year window with which to do that. So the Anti-Terrorism and Effective Death Penalty Act of 1996 actually starts to wither away habeas protections. Two, the Patriot Act comes along, right? The Patriot Act is such that government at the time was able to sort of continue to chip away at habeas. That's why you see people in Guantanamo Bay being held without any sort of hearing until 2008, when the Supreme Court made a decision in a case where Bush is the defendant, where foreign detainees have the right to hear why they're being detained in Guantanamo Bay. That said, what Trump has done, what the Trump administration has done, is sort of continue this trend of chipping away at habeas. And I've always said this, I'll say this to you in other situations. What he does is he tests the limits of laws, and he goes right up to the edge and sees if he can go a little bit farther. And what they've done is masked ICE people now are sort of testing the limits of laws like Anti-Terrorism and Effective Death Penalty Act, Patriot laws and Patriot Act and so on, to make it so that habeas corpus is not quite the same protection it was during the Warren era.
We're talking about the obscure but essential doctrine of habeas corpus and its erosion in our own time. We'll be back in just a moment. Welcome back to the special edition of Listening to America. I'm Clay Jenkinson. Across from me, virtually at least, is my friend Beau Breslin. Beau, let me just make sure we're clear about this. It's okay if the government of the United States wants to change certain provisions of habeas corpus, as long as the courts will affirm that. In other words, during the Warren Court, during the sort of the 1950s, 60s American Enlightenment, we pushed habeas corpus pretty far. Miranda, other protections of prisoners' right to counsel. We pushed that doctrine, and it is possible that we could say we went too far with that. We're going to pull back some. That's legal. There's nothing constitutionally impossible. The question is, what do we mean when we say habeas corpus shall not be infringed? And I think that's where courts come in, and they've been at this forever, since the Magna Carta and up to our own day. So I don't want to make it seem as if it's inherently illegal for an administration to try to narrow the rights of habeas corpus, but you want to have an independent judiciary that will say, well, wait a minute, how do we now evaluate what the founders meant, how the doctrine has evolved over time, what its application is now? We now live in a time of asymmetrical conflict, so maybe war isn't quite the same thing as it was in the Civil War. You understand, of course, that this is what you do. This is how we adjust our understanding of these things, and it is not inherently wrong for an administration to try to narrow this and to test its actions what I find so offensive, Beau, is the sense in which it believes that it's entitled to just roll over doctrines that have been developed since 1215 AD. And because why? Because they just don't feel like using a process that has had a long, agonizing gestation. That seems to me to be just kind of fundamentally indifferent to the rule of law.
So I think you and I are all are in agreement about this and many other things. But let me turn this around to you, Clay, and you pretend like you're Chief Justice Roberts, right? You don't have to play Chief Justice Roberts. You can play Clay Jenkinson on, but pretend you're Chief Justice Roberts, and the Solicitor General comes to argue a case about detention and about immigration policy and law. And they say, well, we see this, the government sees this, sees immigration, the immigration problem as an invasion, quote unquote, an invasion of folks crossing over the border. And you have to decide, Chief Justice Roberts, Clay Jenkinson, you have to decide whether or not Article 1, Section 9, that requires habeas corpus not be suspended except in cases of rebellion and quote unquote invasion. Is that a appropriate interpretation of Article 1, Section 9 or immigration to say that it's an invasion? That's where the rubber hits the road. I'm not going to ask you, although you could, answer the question.
No, I'm going to answer the question, but I'll tell you, the first thing I'm going to do if you're making me Chief Justice Roberts is I'm going to spank Clarence Thomas and take that RV away from him. I'm going to make him pay back his mother's mortgage. I'm going to develop a code of conflict of interest and ethics for the court, and I'm going to give it teeth. So that's what I'm going to do first, because, as you know, as well as anyone, the court's authority is based on its credibility.
Absolutely.
And this is hard for people to understand, but the court has no enforcement arm. Remember, Andrew Jackson famously, but probably not actually, said, the court has made its decision, now let it enforce it. But we get the point. The court's legitimacy is based upon the people's belief that these are fair individuals who love the Constitution, who are trying to do the right thing, who err on the side of due process and on the side of human rights, are more likely to blame government than the people for any serious conflict. That's what we want. That's the idea of the Platonic jurist that Jefferson said doesn't exist. He said, hey, they're people like other people. Don't put too much credibility on these folks. But you want that court. You want the court that does that. And so if I'm Justice Roberts, here's what we do. And you tell me where I'm wrong. You're the constitutional expert. The first thing you do is look at the facts of the case. Then you go back to the founding fathers and you say, all right, under what circumstances was Article 1, Section 9 embedded in the Constitution? We have Madison's notes. We have the Federalist Papers. We have some other accounts of what went on there. We have a fairly distinguished set of documents that surround the brief text, Article 1, Section 9. And so you take a look at that and see what their intention was, what they were frightened of, what they did not want to see happen in this country. The third step is to look at the evolution of habeas corpus over time in American history, because it's not a settled doctrine. It's an evolving doctrine, as all doctrines are. The First Amendment could never have anticipated cyber porn. The First Amendment could never have anticipated some of the wacky religious sensibilities that occur in our time, and so on. The Fourth Amendment could never have anticipated the capacity of a drone to surveil your house while you're in the backyard. So all these doctrines have to be applied and interpreted and evolved over time to fit changing social, technological, and political circumstances. We get that. So I would look at all those things and I would say, all right, what are the recent cases? What are the cases in the 40s, 50s, 60s, and 70s about habeas corpus? How much do we feel we can break with that and still be true to precedent and the way law evolves in a free society? That's how I would start. Wouldn't you?
Yeah, I mean, I do it the same way that you're doing it. I mean, I might go back a little bit farther in history, not just to the Magna Carta, but the Habeas Corpus Act of 1679. Maybe, because the framers were so influenced by what had happened in England and so on, and
the British common law tradition was basically just shuffled into our system.
Yep. So, but other than that, I do it exactly the way you did it. the difficulty, the challenge, and the reason why I'm sort of pushing it on to you is because, I trust your judgment here. The challenge is, how do you interpret the word invasion? As you know, Clay, this is not a kind of an academic rhetorical question. This is the kind of thing that judges have to do every day, is figure out whether or not invasion counts in this context. We can look at Lincoln, and we knew, we look back and we think, oh, Lincoln's suspension of habeas corpus, first in Maryland and then throughout the country, he gets support from Congress in 1863, passed a law that suspended habeas corpus. So
yeah, he did this arbitrarily, as the president can do, but then he sought congressional endorsement of it, and they provided it.
Correct. So he's got folks that are coming to him whose habeas has been suspended. Merriman is the most famous person who comes to him, comes to government and asks for habeas, and it's suspended and so on. We can look back and say, this is my point. We can look back and say, oh, at that Civil War, it made some sense for Lincoln to suspend habeas corpus, and he also got, as I said, Congress's authority there. Right now, does the immigration debacle at the border count as an invasion? The Trump MAGA people would say yes. I would say no. But my decision it means nothing. It's Chief Justice Roberts and the other 8 members of the Supreme Court. That's why I think it's a very tough moment. It's a very tough issue to sort of resolve.
So, but when the founding fathers installed the doctrine of habeas corpus into the Constitution, there wasn't a footnote that said, here are the conditions under which you can call it an invasion. Here is the conditions under which you can call it an insurrection. Here's exactly what we mean by habeas corpus and how it plays itself out. As with so many parts of the Constitution, they were deliberately vague in general, and that puts the courts into the position of having to define it. That's true of almost anything. What is free speech? What is freedom of religion? What is an establishment? And so on. We know that. What's an illegal search and seizure? And you really want those platonic, brilliant scholar judges who are above human politics to weigh in on these questions. Of course, we never get that. And Jefferson famously quoted the Romans saying, if we have guardians, who will guard us against our guardians? But let me make the case for the Trump administration. The perception is that in the last 30 or 40 years, well over 10 million, maybe double that, people have come illegally across the border and are living in this country. They have violated American law. That's a lot of people. That's more than Hitler threw at Britain, or more than Hitler threw at Moscow or Stalingrad. Maybe that's an invasion. It's people who were uninvited, who are unwelcome, who have violated our laws, who have crossed our border. Now, they didn't bring AK-47s, but they did bring themselves, and I think the case can be made that is an invasion army of a certain sort. But I think someone on the other side, and I'll bet that millions and millions of Americans would endorse the view that what has happened in the last 30 years at the border is, in effect, a kind of invasion, and therefore we have a right to interdict it using tools that suspend some of the protections that we would use if this were not so severe a problem.
Yes. And let me just throw a name out there that I think is fascinating in this particular moment. You talk about, sure, Douglas, Brennan, Warren, these people would say that's absurd. You know who might not say that's absurd is Hugo Black, right? Also on the left, but Hugo Black he's a textualist, which means he's literally going to follow what the Constitution says. And if you define invasion as crossing the border and entering with intent to do illegal harm,
without legal license to cross the border,
and I can absolutely see Hugo Black, liberal Hugo Black, absolutist First Amendment Hugo Black, saying to the Trump administration, yeah, that's an invasion. You can suspend habeas corpus in that moment. So it's not just a right-left issue, it's a constitutional interpretation issue that is super complicated.
We've seen a very wide and deep erosion of what I would call the basis of what a republic is. And now I think we're beginning to behave like a country with interests rather than a nation of principle.
Sure. I mean, I'm sure a lot of the listeners will take umbrage with what I'm going to say, but we were and have been historically the world's empath in terms of humanity. And
again and again and again, imperfectly.
Yeah, imperfectly, and not always the case. But we could actually wrap ourselves in the flag and say that we were doing the moral best we could in most circumstances. I don't think we can do that anymore. And I'm not sure it's just a Trump administration moment. I think it actually has been a 21st century problem for us.
I agree. I think that the big mistake we can make on a question like this is just saying Trump, 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 Trump. Right. He's first of all, he's a symptom rather than the cause of much of this. There's been an erosion of American understanding of what's at stake. And so that's my question for you. You teach college courses. Let's say you have a class on the American Constitution 101, and these are sophomores or freshmen at Skidmore, and there are 40 students in the class. If you said, take out a sheet of paper and write down the definition of habeas corpus and why it's important, I'll give you 5 minutes. What do you think you get?
I actually think I would get only a handful of accurate answers.
Yes, by students who are college students at an elite college who are taking a course in political theory or the Constitution of the United States. Even there, you would be hard-pressed to get more than a handful of people who really understood what habeas corpus is.
Correct. And I think that, when you look at the data, it is pretty alarming to know that at least 8 out of 10 Americans can't really tell you anything that's going on in what's in the Constitution. Most Americans will confuse the Declaration of Independence and the Constitution. There is no life, liberty, or the pursuit of happiness in the Constitution. Most don't know basic structural stuff. And this is not a moment in which to disparage. This is a moment in which we need to put the mirror up in front of us and think about what it means to be a citizen of a free society like America.
Your students at this elite institution called Skidmore probably couldn't do this. Imagine the average American. They hear, oh, Kristi Noem said something crazy about the habeas corpus. If they don't know what that is, if they don't know the long agonizing history of developing that doctrine, if they don't know how many people in the history of even the West, even the Anglo-American world have disappeared without due process, if they don't realize how central this is to the human condition, to human rights, how can they possibly check a government that's getting out of control?
They can't. And I think one of the things that happens in American society these days is there is a lack of check from the public, right? What happened to the notion of res publica? What happened to the notion of we are citizens and that the common good is our primary interest, right? So whether it's Madison talking about factions or Jefferson talking about what it means to be a citizen of this republic, we've lost sight of what that means. And I think it all boils down, Clay, to education, education, education. It's hard for me to be such a naysayer, but I do think civics education has failed us over the last half of my life. And I'm 59, so the last 30 years have not been good when it comes to civics education.
So I would hope that in your class, when you do this next semester and they fail, you'd say, go away, class is canceled, come back when you know what habeas corpus is, and then see what happens on Thursday. So, all right, so, we understand this erosion, and Jefferson was absolutely right. As always, if you expect to be a nation ignorant and free, you expect what never has been and never can be. That this doesn't work unless you have a well-educated, well-informed citizenry who know what's at stake, know their rights, know what can go wrong in a republic, know when abuse is occurring, know what an emolument is, know what the purpose of the pardon clause is, know what an impeachment clause is meant to do, know why all wars must begin in the House of Representatives, know why the president doesn't have unilateral authority to commit war in the rest of the world. Unless you know that stuff, then you have no capacity to say, I don't think this is right. I don't think this is within the tradition of American constitutionalism. And if you asked, not your students, but 100 people on the street who are, say, 20, what's the Constitution? I think they would say, I got free speech and free religion. I have the right to invoke the Fifth, and I get to have a gun.
Yeah, I think those are probably the three. Maybe they could say "we the people," right? Maybe the preamble would come up a little bit, but yeah, beyond that, I think it's so interesting to me. So I talk about to my students about this sort of stuff, and I say to them, have you ever been to the National Archives? People should go to the National Archives, and go into the great majestic room in which they have the original Declaration of Independence and they have the original copy of the Constitution. They even have Madison's original 19 amendments that he proposed that became condensed to 17, and 12 passed Congress and 10 were ratified by the states. That's why we have a Bill of Rights. They've got this great stuff. And I say to them, to those who were there, I said, what did you do? And inevitably, the first thing that anybody does in that moment is go and look at the Declaration of Independence, where you can only see John Hancock's signature. But the second thing they do, they go to the Bill of Rights before they go to the original constitutional text. The reality is the Bill of Rights has sort of placed the original 7 articles in a shadow. And that's not what we want when we come to understand the meaning of citizen, popular sovereignty, and so on. We need to understand how the institutions work. We need to understand about amendments. I'm a big fan of Article 7 about ratification, because I think everybody should take a moment to think about whether they would want to ratify this Constitution. You should have a personal relation with the Constitution itself. That has been lost both at school and in the culture at large.
We need to take a break. I'm talking to my friend Beau Breslin. We're having such a good time. When we come back, I want to ask you more questions about this, Beau. And particularly, I want to talk about a couple of moments in American history when we have suspended habeas corpus and why we now usually regret it. We'll be back in just a moment. Welcome back to the special edition of Listening to America. Beau Breslin is the author of a number of books, including one arguing that we should renew the Constitution every 20 years or so, and he offered 5 patterns for that to keep it current. Jefferson famously said, you may as well require a man to wear the coat that fitted him as a child as to require our civilized citizens to live under the barbarous regimen of their ancestors. I'm 100% on board with that. I know we all fear a constitutional convention in our time, but for the moment, we're talking about habeas corpus. And you have a right to have a public engagement with the judicial system. You must be told why you have been arrested and incarcerated. Do you have a right to counsel?
Not under habeas corpus, but obviously under other parts of the Bill of Rights.
Expansions of the Bill of Rights in the Warren era. Miranda, for example, right to counsel, right not to incriminate oneself, right to be quiet after being arrested. If you think of all the times, including now, of course, that arrested people have been roughed up, forced to confess, forced to make false confessions, had incriminating evidence planted in their vehicles or in their persons or purses. That's why we have habeas corpus, to be able to say, hey, you can't just make me disappear. You have got to let me be recognized by the state as someone who has rights and can argue for those rights. And if you don't allow that, there will be a lot of arbitrary detentions and disappearances. So let's look at a couple of these. So Lincoln suspends habeas corpus. We get that. If ever there was an emergency in the United States, it was 1861. Back in Jefferson's time, the Alien and Sedition laws, especially the Alien Enemies Act, which is being reintroduced, re-upped in our own time, absurd. There should be a permanent sunset clause on most legislation. But here we are. You just have to imagine people in this administration or any other administration searching history, trying to find a legal basis for something they want to do. So the Alien Enemies Law of 1798 said that the President of the United States could expel from this country any foreign person he regarded as a security risk without due process, period. There is a fundamental violation of habeas corpus.
Absolutely. And, I think the resurrection of that particular black mark in American history in the Adams administration. That particular resurrection in our contemporary era, in some ways, the most troubling thing that I've seen an administration do in a long time. Clay, not only is that sort of going against this sort of empathetic American spirit, but it's also resurrecting something that most people thought was the early republic's weakest moment.
Exactly. The most embarrassing fact of the early national period is the Quasi-War, the Alien Act, the Alien Enemies Act, the Sedition Act, the Naturalization Act. We now blush when we think about this. And again, Jefferson was right. He said this is going to precipitate a change of administrations. The American people will not put up with this. He said these laws are worthy of the 8th or 9th century, not an enlightened republic. And he was right. But nations do this, and we've done it again and again in times of perceived or real emergency. Take Guantanamo. I mean, luckily in 2008, the Supreme Court said, hey, wait a minute, there has to be at least limited due process here. You just can't lock people up forever without giving them access to assert themselves or to counsel. But, you know, you said 2008, that means some of those prisoners had been there for 3 years already without access to legal aid. There are people that are still at Guantanamo. We also did extraordinary renditions in other parts of the world which had no due process whatsoever. Guantanamo was like the House of the Bill of Rights compared to sending someone into a country where they can just be tortured or killed with impunity. So this was another, and guess what? It was in a period of national paranoia, just, I think, coming after 9/11. And so we basically said, we're going to need a lot stronger executive. Torture isn't going to mean what maybe the Geneva Convention says it means. We'll call it enhanced interrogation. We might have to do some renditions to countries that don't have a Bill of Rights, so the least we can cover ourselves. And some of these guys are schnooks that we're just going to lock up at Guantanamo and not think too much about it. But it came out of a real sense of national emergency on 9/11. And we now, looking back on it, can say, well, we overreacted some. But at the time, they felt it. Take another one, Beau. Japanese internment in World War II. I mean, by executive order, FDR, one of my heroes, one of my 4 or 5 greatest American heroes. This happens, right?
Yeah, and what's interesting, Clay, is that inevitably the review, the look back, is with regret.
Right? Always, almost always.
Almost always. And so, sure, you know, we lived through 9/11, and I thought the Patriot Act probably had some wisdom to it, and throwing people in Guantanamo Bay. You remember during those early period, we didn't know about the enhanced interrogation, right? It's only come out a little bit later, but the fervor of the post 9/11 moment suggested that was the right thing to do. In hindsight, not so much. I still don't think that FDR got it right at all with regard to the internment of Japanese Americans on the West Coast. But inevitably, it was a regrettable moment. And what's interesting, you'll recall, Clay, that it was the Harvard UNC affirmative action case that just was decided, 2 years ago, something like that, where the court ironically overturns the Korematsu, the very famous internment case, in which the Supreme Court said, yes, it's okay for government to intern the Japanese Americans. That's 70 years later? So inevitably there's regret associated with the suspension of habeas corpus. And, I think I hope we learn our lesson down the road.
And that's why you want an independent judicial system that can say, sure, we're all scared. Of course, this is an emergency. This attack on the World Trade Center and the Pentagon and who knows what else was being planned. We're going to have to do some really extraordinary things to survive this. But you want the court to say, yeah, okay, I hear you. But let's make sure we preserve the Constitution and preserve the most sacred principles of American life to the maximum extent possible in a situation like this. And let me give you an example. I have a friend named Lisa up at Lake Tahoe, and we were talking about the death penalty once. And I said, well, if my daughter were killed, I'd want to go kill the person who did this. And she said, of course you would. But she said, But we have a system in which someone will stand between you and that vengeance, a system, a process, and you might be frustrated by it, but we can only have a civil society if we step between you and your desire for vengeance. And that really struck me as exactly right. And the same thing is true of Abu Ghraib and Guantanamo and so on. Extraordinary rendition. You want your system to say, I don't think this is in keeping with American life, however desirable or however urgent it may seem. Is that really what we want to be doing as a people? We're not at the moment, and I think this has been true for a long time, that our judicial system has not been, has gotten into this weird business about textualism and originalism and all of that. It has failed to realize that it exists to protect the rights of the American people.
Absolutely. And so let's have a little moment in which we remember what the different institutions of American government are supposed to do, right? I talk to my students about this all the time. This was the original design. So Congress, by that I mean the House of Representatives, is meant to protect the interests of local communities. That's why you have 2-year term limits. That's why there's so many in the lower house. The Senate is meant to protect the interests of states. That's why you don't split the state in half. Each of the 2 senators is supposed to represent the interests of the states. The president is supposed to represent the interests of the entire United States. That's why someday it'll be she, but he is elected by the entire population. And here's the point, Clay. The judiciary, life tenure and fixed salaries, is meant to protect those who do not have a voice in the political process. We can call them minorities, but everybody always thinks of racial and ethnic minorities. No, they're meant to protect the interests of those who do not have a voice in the political process. That includes Guantanamo Bay detainees. That includes Abu Ghraib. That includes those who are being deported. And that includes those who want to say something so outrageous that they might get in trouble, and the First Amendment protects them. The goal, the design of the judiciary is to protect those who need the rights, those who don't have a voice in the political process. That's why the federal judiciary has life tenure and fixed salaries. Now, we can argue about that design, but that was the original point, and that has worked well, and we should celebrate that part of the judiciary's role.
I would say that has worked pretty well over the course of American history. I do think that justices are humans like all other humans, with great days and bad days and prejudices and favorites and absurd. These are people like other people. So this is really a terrific and important conversation, and I so appreciate the clarity of your thinking. Should try to have a conversation with those around them about where habeas corpus comes from and why it's so essential. So with your permission, if you don't mind, I'll read this. It's quite short, but I think you will. I want to get your reaction before we close. If we were a republic, or even a healthy democracy, and the Director of Homeland Security, when asked to define habeas corpus, declared that it was, quote, the right that the president has to be able to remove people from this country. If we were a republic, she or he would resign in shame or be forced to resign, because what was uttered in the United States Senate was not only the complete opposite of what habeas corpus is, but its fundamental purpose, habeas corpus, is to prevent a president or any other government entity from removing people from the community without due process. In other words, the Department of Homeland Security is all about habeas corpus. We are no longer a republic, of course. We live at a time when tens of millions of Americans believe that they would be okay with the denial of habeas corpus to individuals they want to banish from this country. What the Director of Homeland Security said was not only ludicrous and fundamentally erroneous, but a revelation of the determined indifference of the administration she serves toward the most fundamental of human rights. There's been a lot of talk about habeas corpus over the last 6 months, but I find that most Americans aren't really sure what it means. Most people seem to regard habeas corpus as some sort of legal nicety or an arcane procedural tidbit in the judicial process. But in fact, the right of habeas corpus is one of the most important rights we have arguably the most important. In simplest terms, the right of habeas corpus means that nobody can be jailed without due process. The Latin phrase literally means you have the body, but a better translation would be you must produce the body, the person you have arrested. Some version of habeas corpus has been around for almost as long as Western civilization, but it is to the English that we are most indebted. An adumbration of habeas corpus found its first formulation back in the Roman Republic, where the accused had what we now regard as very, very limited rights. And it wasn't until the Magna Carta of 1215 that medieval English law began to approach the suburbs of the doctrine of habeas corpus. Article 39 of Magna Carta says, quote, "No freeman shall be taken or imprisoned but by lawful judgment of his peers or by the law of the land." It's a good start. In other words, no arbitrary disappearances or incarcerations. Between the 13th and 16th centuries, English courts developed a limited doctrine of habeas corpus to demand that jailers come forward to justify a person's detention. In the later 17th century, the British Parliament passed the Habeas Corpus Act of 1679. This was an exceedingly important landmark in the history of human rights. The 1679 law required jailers to physically present prisoners before a court within a set time frame, and it prohibited jailers from moving a detainee around to different locations to evade legal writs. The founders of the United States, many of them outstanding students of the history of law, inherited and incorporated the English common law formulation of the right of habeas corpus. In fact, habeas corpus was regarded as so important to human liberty that the Founding Fathers did not leave it for the Bill of Rights. They embedded it directly into the heart of the Constitution. Article 1, Section 9 of the Constitution states, quote, "The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it," end quote. Habeas corpus may be the single most important of human rights. If a government or autocrat can simply make you disappear, jail you for life, torture you, kill you with no legal jeopardy, without ever having to justify his actions or express the reason for your arrest and incarceration, without ever allowing a judge or a lawyer to question the circumstances of the arrest or the punishment, then you have violated the most sacred principle of an enlightened civilization, and you are at or on the road to tyranny. When governments suspend or ignore habeas corpus, they almost always later feel ashamed of those actions. Think of the Japanese Americans who were rounded up and forced into remote internment camps in the 1940s. Their habeas corpus rights were ignored. That action by the FDR administration is now regarded as one of the principal failures of American constitutional jurisprudence. In 2025, not 1381, people are disappearing from the streets of America every day, nabbed by masked federal agents who refuse to show their badges. They are plucked out of stores, parking lots, government buildings, even churches, and for many, that's the last we hear of them, at least in the short term. You would have thought that this would be a no-brainer for the Supreme Court of the United States. Habeas corpus is enshrined in the first article of the Constitution, after all. But we live in a time when the people of the United States do not hold their government accountable. The case can be made that undocumented immigrants who have committed serious crimes should be expelled from the United States. If we are allowing undocumented individuals to live here illegally, it seems to me we can impose a zero-tolerance policy for felonious crimes. But our procedures need to conform to the laws of the United States and the laws of humanity. Article 1, Section 9 of the United Nations Universal Declaration of Rights states, quote, "No one shall be subjected to arbitrary arrest, detention, or exile." I don't see how the case can ever be made for snatching people off the street, refusing them counsel, performing no act of due process, and causing them for all practical purposes to disappear. Disappearances are the stuff of the 1980s in El Salvador, Nicaragua, or South Africa for that matter. I'm sorry to say we Americans played fast and loose with disappearances during the Gulf Wars, but at least then there was a genuine enemy that constituted a serious threat to us. It's not very sexy, but we should be marching in the streets by the hundreds of thousands or millions with homemade placards and chants of "We demand habeas corpus, we demand habeas corpus." It's that important. And if we were a republic, that's exactly what we do. Nobody who loves America or liberty should be okay with this. Probably the Director of Homeland Security was coached to respond to the Senator's question in this way, but it was not only embarrassing on a personal level, but an indication of how far we are now veering from the fundamental principles of a free and enlightened society. I'm Clay Jenkinson. What do you think, Beau?
No, I think that's fantastic. As you know, I think it's just spot on. And at the risk, Clay, of shaming your man Jefferson for a moment, I think I'll close by quoting John Marshall in Marbury versus Madison, who took a jab at Mr. Jefferson when he said, "There should be no doubt, quote, there should be no doubt that ours is a government of laws and not of men. Habeas corpus is the most important," this is my point, "habeas corpus is the most important protection against the impulses of any man."
Absolutely. Amen. I'm sorry that you had to, quote John Marshall here to kind of recover some dignity here. It's okay. Marshall was very wise. Jefferson said that, he called him that gloomy malignity. Said that he liked to frequent taverns and public houses, that he really wasn't a full gentleman by any strict meaning of that term. But you know what? In my opinion, John Marshall was one of the 5 or 6 greatest justices in the history of the court. And we're lucky that he checked Jefferson. At the same time, we're lucky that Jefferson checked him. So thank you, Beau. We'll see everybody next week for another important edition of Listening to America.